Please be seated. We'll now hear our second case on the docket today, WR-95 541-01, ex parte Leroy Hilbert Zubiate. We will hear first from counsel for the applicant. Could you please state your name, both of you, when you approach the microphone so that the recording will make it easier to know who was who? Thanks.
May it please the court, I'm John Bennett. This case is from Howard County. Counsel? I'd like first to clear up one or two things I got wrong in my brief. There was a determination of good cause of sorts at Mr. Zubiate's preliminary revocation hearing. That determination of good cause was not for live witnesses. It was for whether the hearing officer would permit written material without the authors being on Zoom. So that sidesteps the question. Nevertheless, what I said was wrong. Also, my brief says the only allegation sustained at the final revocation hearing was the bracelet strap alert. It's not so. The failure to report to his parole officer was also sustained. I apologize to the court for these errors. Also, the state brief points out that the rules of appellate procedure do not apply to a habeas case. I agree with that to an extent. The state has set up a mechanism by which probation revocation cases may be appealed, but not parole revocation cases appealed. So it seems a bit unfair to deny Mr. Zubiate the benefit of the rules of appellate procedure.
Well, thank you for those clarifications. If I could bring you forward a little bit, though, I think the critical question here is whether the confrontation clause applied to this proceeding at all. Can you help me with that?
Yes, Your Honor.
Did the Supreme Court address that in Gagnon, I think, in a footnote?
Actually, it's applied in Morrissey versus Brewer and then amplified it in Gagnon, I believe.
Okay, so help me out there.
Okay.
Why does it apply?
Well, the state brief tries to distinguish parole revocations from other types of cases on the ground that parole revocation is not a criminal proceeding. This is likely correct, but it's irrelevant because Morrissey versus Brewer was directly applicable to parole cases because it says so. These were parole revocation inmates whose parole was revoked. Chief Justice Berger began the majority opinion saying, "We granted certiorari in this case to determine whether the due process clause of the 14th Amendment requires that the state afford an individual some opportunity to be heard prior to his revoking his parole."
I understand, but that was due process, right? That's a different requirement than the Sixth Amendment confrontation clause, right?
I believe it lumps them both in.
Okay.
The Morrissey does say you have a parole, a parolee facing revocation has a right to confrontation and cross-examination subject to a good cause determination, which the hearing officer can make. The prior precedent, including Haggard and Justice Scalia's opinion on it, at least cast doubt on the appropriateness of Zoom testimony at an absent good cause at a parole revocation hearing. The state brief points to a case from the Court of Appeals from 2022 equating Zoom testimony with live testimony, but that flies in the face of all those cases. Here, we are not asking you to pass on that question. We're only asking that under Morrissey, hearing officers make a good cause determination before admitting Zoom testimony. What constitutes good cause is a question for another day, of course. But Zoom testimony at these hearings should be used sparingly when there is a good determination of good cause. Gagnon versus Capelli, yes, addresses this question sort of, but it expands the holding in Morrissey versus Brewer. It says not only letters can you introduce, but hearsay testimony, yes, you can introduce them. Creative solutions to parole revocation hearings, of which Zoom testimony is certainly one. But under Morrissey versus Brewer, it doesn't retreat from the holding that you have to have good cause to let this stuff in. Here, I filed a motion beforehand before each hearing to have a live hearing so that they could have live testimony. Both were rejected out of hand.
So, can I ask a question?
Yes, of course, Your Honor.
The court has crafted an issue that focuses on the confrontation clause of the Sixth Amendment, right?
Yes, Your Honor.
And one of the things that I'm curious about is, I looked at the ground in the actual writ application, and even though some of the facts supporting that ground invoke the clause, which I would call the Sixth Amendment clause, the ground seems potentially broader. And what it causes me to wonder is if, for example, we decide the case that we asked you all to brief, which involves the confrontation clause itself, against you, is that sufficient to resolve the claim, more broadly spoken, that this person, your client, was denied his right to confrontation in a more general sense?
I believe so, Your Honor. Yes, because he was denied a good faith determination.
So you're saying that the confrontation clause of the Sixth Amendment and any confrontation that was due under the due process clause are exactly the same? Or are they distinct? And could your client maybe have been entitled to relief under the due process clause, but maybe not under the confrontation clause?
It's possible, Your Honor, but with all due respect, I think it's irrelevant. The Morrissey versus Brewer was a state case. Came out of, I forget which case.
Focus on one or the other?
Beg pardon?
Confrontation versus due process?
Yes, I don't see a difference here, or I see a difference, but I don't see a meaningful difference because the Supreme Court in Morrissey absolutely said confrontation and cross-examination, but qualified by good cause.
And what right did your defendant have a right, for example, to rely upon a right to confront witnesses that might or might not have been guaranteed by the rules of the parole board? Because the rules of the parole board, as I understand it, also stated that there was some right to confrontation, perhaps.
Yes, they parrot Morrissey versus Brewer, Your Honor.
So these rights there's three levels, it seems to me, of potential avenues for a right to confrontation. The confrontation clause of the Sixth Amendment, the due process clause, 14th Amendment, and then also the rules. So which one are you primarily relying upon, and is there a reason to distinguish any of them?
Primarily Morrissey versus Brewer, which cites the confrontation clause, and no, I see no reason to distinguish them, with all due respect. The state brief...
Have some circuits, some federal circuit courts of appeals have addressed this, have they not?
I think so, but they're not.
Have they drawn a distinction between what would be your confrontation right as an aspect of the due process clause and the Sixth Amendment confrontation clause?
Not that I've read, Your Honor. No.
But just so I'm clear,
yes,
your
sir.
position is that the attack under the confrontation clause is exactly equal to the attack under due process. Your position is there's no broader due process rights or analysis. It's simply limited to the confrontation clause attack.
Under Morrissey versus Brewer, it would seem so, yes, Your Honor.
And in this case, that's your limitation, the confrontation clause attack.
Yes, Your Honor. And the fact that it was not, it might have been dispensed with, but it wasn't, because they made no good cause determination whatsoever at the final revocation hearing. The state brief also says that Mr. Zubiate did not cross-examine or contest the relevant testimony. This is an honest mistake, I realize that. Having done hundreds of these hearings, the reports that the hearing officers make do not distinguish between the testimony given on cross-examination and on direct examination. The hearing officer simply writes down what he or she thinks is the highlight, the meat of what the person testified to. So it looks like there was no cross-examination. This is nothing against Mr. Tadema here, but no, I was the one who represented Mr. Zubiate at the parole revocation hearings, and I always cross-examine them. So a tape recording of the hearing is in the custody of a state agency, presumably the TDCJ Parole Division. The state brief closes by saying that Morrissey and Gagnon never intended to handcuff administrative hearings to 1970s technology. No, they didn't. They didn't intend to do so. They merely restrict non-live testimony to situations in which good cause exists. There is no restriction so long as a determination of good cause is made to deny confrontation cross-examination. That's not only what Morrissey versus Brewer says, but that's what the board's own rules say. On the question of harm, whether it's my burden under because this is a habeas case, or possibly somewhat the state's burden under Rule 44.2a, Haggard cites the Van Arsdale factors, the importance of the witness testimony, whether the testimony is cumulative, corroborating and contradictory testimony, the extent of cross-examination otherwise permitted, and the overall strength of the case. Particularly on the failure to report, this was merely my client's word versus the parole officer's word. So that is a definite issue which might have been resolved by actual live testimony. Excuse me. I'm running out of time. In these hearings and anything by Zoom, the speaker is usually not looking at the camera. The speaker is looking at the image on his or her screen. So he's not looking directly at the hearing officer. So the hearing officer doesn't have the benefit of all those clues that we can use to determine whether the person has credibility or not. I mean, if the person looks directly in the eye and says, this happened, that happened, or if he says, well, this happened, that happened, they don't have the benefit of that. So it seems there is plenty of harm here. Whoever must bear the burden.
Just a quick clarification.
Yes,
If I
sir.
understood you correctly, you said, if I understood, the probation officer testified, he didn't report. Your client testified, I did report. And if I heard you correctly, you said, had this been in a live hearing, the trier of fact may have discredited the parole officer's testimony and credited your client's testimony and found that the parole officer was misrepresenting to the court that he had failed to report?
Yes, Your Honor. However, my client didn't testify, but he did deny the allegation. So, in essence, that's correct. I believe I'm almost out of time. If the court has any questions, please.
Counsel, appreciate that. If you'd like to yield your remaining time for rebuttal, we'll look forward to hearing
Thank you very
from
much.
then.
Thank you.
Thank you so much. We will now hear from counsel for the state. If you could again identify yourself when you get to the microphone, we'd appreciate it. Thank you.
Can you hear me okay? Yeah. May it please the court, counsel. My name is Nathan Tadema, and I'm appearing on behalf of the state of Texas and from Howard County. The state fully protected Zubiate's right to confrontation in his parole revocation hearing. He enjoyed fair, free, and unfettered communication, visual and audio communication with all of the witnesses, the hearing officer, and his attorney. He cannot articulate how Zoom impeded his ability to suss out the truth at his hearing or cross-examine any of the witnesses. Simply put, his Zoom parole revocation hearing was the functional equivalent of a live in-person hearing.
I don't want to cut you off too quickly here, but counsel just said something different than that. He said that when you're looking at a screen, when you're operating through Zoom, that you're just looking at the screen. You're not, it changes the ability of the fact finder to assess whether there is credibility to what you're saying or not. So how do you reconcile, do you just say, I just disagree with him about that? Or is there some science behind this that I'm unaware of?
I mean, I would start with, yes, I disagree with him on that. The goal of a parole revocation hearing is just to give him an opportunity to question witnesses and suss out the truth of what's going on at the hearing. He has the opportunity to ask them questions, and whether they can look him directly in the eye really doesn't impede his ability to determine what the truth of the matter
Well,
is.
we just heard a pretty substantial capital murder case. I don't know if you were here to watch it, but could that case have been tried in full by Zoom?
No, not at all.
Okay, so why is this different?
Because this is an administrative hearing.
Okay, so really it doesn't matter, well, let me ask you a formal question. Does it matter whether what the efficacy of Zoom is, and what would we cite if we were to agree with you that it was sufficient here, but it wouldn't have been sufficient to try on the merits, guilt or innocence in a capital murder case?
Well, I would, the main case I would cite for you guys is Wilkins v. Timmerman Cooper, which is out of the Sixth Circuit Court of Appeals. In that case, it was a state parole revocation hearing, even though it's heard by the Federal Circuit Court. And in that case, it was held entirely over a teleconferencing application. And the only real difference in that case was that it was a much more hotly contested case. It was a sexual assault of a child, disputed allegation in a parole revocation hearing. And the parolee in that case actually introduced an expert witness saying, basically what my friend across the aisle was saying, he argued that the communication over a teleconferencing app just isn't as good as in-person testimony. But the Sixth Circuit expressly rejected that argument, that expert testimony from the parolee. It said, quote, because the parolee was able to confront his accusers, quote, because he observed, heard, and questioned them in real time. I would argue that that conclusion is equally applicable in this case.
That was a due process case, was it not?
Yes.
Okay, so is the answer perhaps that in a capital murder case or other cases where guilt or innocence is being tried with all the protections afforded to the accused to determine guilt or innocence, that the confrontation clause would cover the proceeding, but in the context of a parole revocation hearing, correct? What's the standard of proof there? It's not beyond reasonable doubt, right? It's,
In a parole revocation hearing, it's preponderance of that.
yeah, okay. So, but the due process clause would apply.
Yes.
Okay, and so is it possible, per Wilkins or other cases in the federal system, that a teleconference would satisfy due process in some cases, perhaps, but not the confrontation clause, were it to apply?
I wouldn't say just possible. In a case like this, it definitely satisfies the right to confrontation. The confrontation clause of the Sixth Amendment does not apply to this case at all, despite what my friend across the aisle says. Case after case after case distinguishes between the confrontation clause of the Sixth Amendment versus the right to confront witnesses.
Does the due process clause require good cause to have a non-live witness appear for purposes of the revocation hearing?
It requires a good cause to deny their right to confront an adversarial witness. But in this case, our position is that he had the right, he had the ability to confront the witnesses. He was confronting them over Zoom. And actually, in the two main witnesses in this case, and I guess we have a little bit of factual dispute, but I don't believe he.
But it would be like confrontation light, let's say, right? Because it wouldn't work. I think he conceded to me it would not work at trial, like guilt or innocence in a felony trial.
I'm not saying it wouldn't work. I'm just saying the precedent is settled at a criminal trial. I think, that precedent occurred before teleconferencing apps even existed. And criminal trials, you're dealing with somebody, you're dealing with the question of whether you're going to imprison an innocent person. Parole revocation hearing, we're talking about a convicted felon here. This guy's been convicted of shooting somebody. He's still serving his sentence for that crime. The question is much different here. This is an administrative case that occurs with an executive branch, and a criminal trial occurs in the judicial branch. The Supreme Court and Scarpelli and Morrissey both make it very clear that these are very different circumstances in criminal trial versus administrative.
What if it had been affidavits instead?
The hearing officer would have to make a determination about the reliability of the affidavit. Morrissey makes it clear that affidavits are sometimes acceptable in a due process.
So if I understand your position correctly, that it wouldn't matter if there was good cause or not good cause, if the entire state of Texas prison apparatus wants to move over to Zoom hearings for every parole revocation in the state, they don't need to make a good cause finding. They can just start doing that tomorrow.
That is our position, because the Zoom protects their right to confront. They are able to question the witnesses, observe the witnesses, and interact with them in real time.
Excuse me, counsel. Have you ever been a trial lawyer, or you just primarily a lawyer?
I did 1 year as a prosecutor.
Okay, so are you telling us that you could cross-examine someone just as well by Zoom as you can when you're face-to-face with that person?
I think a skilled trial attorney would have some benefit of doing an in-person cross-examination. That's why it's protected in a criminal context. But we're talking about parole revocation context where you're not even entitled to a right to counsel, or it's very conditional, the right to counsel.
But even in a parole revocation hearing, wouldn't you agree that a really good trial lawyer who is able to cross-examine the witness and the way that he's used to doing it, he's gonna do a much, much better job at poking holes in everything this guy says if he's face to face rather than on some Zoom hearing on a TV screen.
I don't think that's entirely clear. Like I said, maybe a seasoned trial attorney is very good at cross-examination. But in a case like this, where he didn't even ask questions of the key witnesses, no, I don't think it would make a difference. And generally in a parole.
Let me ask you this,
Go
please.
ahead.
In light of that, let's assume that it is not as good to cross-examine over Zoom. Let's just say, concede that point for a moment. Isn't it good enough for the due process clause as opposed to the confrontation clause? Isn't that the difference?
Yes.
Because it is confrontation light under due process.
Yes, you're correct. It is I guess I think of it as like the confrontation clause under Sixman is kind of big C confrontation, and
Right.
confrontation under due process is kind of little c confrontation. And case after case has said the confrontation under due process is not as strict, and that's why you're allowed to do a Zoom confrontation in a due process context, but not in a criminal trial context. And yes, a criminal trial, in-person cross-examination is slightly better, and that's because the stakes are so high in a criminal trial. Here, we're in an administrative hearing. Sorry.
When you say not as strict, right, that's confrontation light, we're calling it, but
Sure.
what are the sort of outline of that? Is it really just a different kind? Do we have to have a different definition of confrontation or under the due process clause than the definition of confrontation under the confrontation clause? Or is it that there's excuses for not that are available under the due process clause that may not be available under the confrontation clause? For example, one of those excuses might be when there is good cause. Is that the way it works? Or is it just a whole different definition of confrontation?
I think it's a slightly different definition of confrontation based on the precedent that exists. Right? Precedent after precedent says you have to testify in person unless you have a necessity type of finding.
Isn't the touchstone
Court.
of due process notice and an opportunity to be heard? I mean, if you go back to Matthews v. Eldridge, it's circumstance-driven, right? I mean, sometimes you can deprive somebody of liberty or property with a hearing after the fact. Kids suspended from school, for example. I mean, the fact pattern we have here, and I'm getting back to the universal argument I asked you about, and you said yes to, about could we conduct all these parole revocation hearings? We're talking about a universe of people who have been convicted of felonies, who are in custody. We've said, we're gonna let you, notwithstanding your sentence, go home for a while if you promise to behave yourself. Now, in that context, how do we animate the right to a fair hearing with respect to the ability to see live and in person people who might be offering testimony that would be relevant to the determination of whether you ought to go back to prison? How do we put meat on that bone? How do we answer my question between the affidavits and Zoom and live? What's the best case for us to look to say this far and no farther?
Well, I would redirect to Wilkins, which what they look for is, like I said, they look for the fact that you can observe, hear, and question the witness in real time. It seems to suffice under the due process clause. I'd also point to
But is it reasonable, is sort of the touchstone of the whole thing? I mean, what would the cost to the state be to bring the witnesses live to a parole revocation hearing? If the guy's down the hall, isn't it different from if he's halfway across the state?
Sure, it's highly variable depending on the geography.
But again, we don't have any specific evidence of that on our record with respect to this Zoom hearing, right?
No.
If I understand it correctly, please correct me if I don't, is that it wouldn't matter. Zoom is good enough, period, for parole revocations.
Yes, that's our position. You are getting to confront the witnesses in this case. And another case I would point to is DSV States, the Dallas Appellate Court case. They actually defined, it was a criminal case, so it's a heightened standard, but they defined the salutary effects of face-to-face confrontation, and they defined 4 factors you can consider when determining whether they get the salutary effects of confrontation. I think that'd be good guidance for this case, because in that case they say, the courts must consider whether the statement is given under oath, which it was in this case, whether the witness was subject to cross-examination, which they were in this case, whether the jury can observe the demeanor of the witness, the hearing officer could observe the demeanor of the witness over Zoom, and whether there's a reduced risk that the witness will wrongfully implicate innocent defendants. And there's no indication that there's any increased risk of wrongful implication just because you're over Zoom. So I would point to cases like that where the courts repeatedly define confrontation in a way that Zoom satisfies that definition of confrontation.
Counsel,
Yes, sir.
how contested was this hearing? For instance, were there exhibits that counsel needed to hand this witness? Were there detailed documents that he needed to go through line by line? Was there any evidence in the record, or is there any evidence in the record contesting the failure to report finding?
No, well, other than his plea, he did deny it through the plea, but he did not offer any evidence to contest the two allegations that were found to be true. There were two that were found not to be true, and he did contest those two. So his confrontation was successful with the other two allegations, because one allegation was that he allegedly assaulted his brother, and he was able to cross-examine two police officers and a fire marshal on that allegation. And
Successfully.
Successfully, and the hearing officer found the allegation to be not true. And in addition, he's also found to be cutting off his GPS monitor. In that case, he didn't dispute the testimony at all. We had a parole officer come in and say he cut off his GPS monitor. I got an alert, an electronic alert. Then I showed up to his house, and his mother handed me the broken GPS monitor. He didn't ask any questions of that witness, not on that issue.
Was there also an allegation that he had failed to pay court-ordered reimbursement to the,
Yes.
to the restitution?
And that was found not true, and he did cross-examine on that question. He asked whether the parole officer knew he had the ability to pay, and an ability to pay is an affirmative defense.
That was via Zoom,
That was all via Zoom.
and it was a pretty effective cross-examination.
Yes. So yeah, he's found true on 2 out of 4. So he's able to effectively defend his case on 2 out of 4 allegations, even in this case. So
Well, what if they had found them all true? Would that really make any difference in the legal analysis?
ultimately no, but I think it illustrates that he was getting his opportunity to confront witnesses, and he used it effectively in this case. So the idea that he wasn't able to confront witnesses is just, it's refuted by this case, his own case. I'd like to touch on, before I run out of time, there's some important public policy interests to all of this that make this case important, because it's not just about Zubiate. The state of Texas conducts thousands of parole revocation hearings, and most of those are by Zoom now. The benefits of this technology have greatly outweighed any of the negative effects, any theoretical negative effects.
Let me ask a question. I'm with you on the public policy. Do you make your population sign anything when they accept parole and they leave your custody?
Yes.
Why not say, I agree to Zoom? If we have to go drag you back here, you agree to Zoom for the hearing?
Because we're granting them a right to confrontation. They don't have a,
Okay.
we're not denying them a right by having it over Zoom.
Not sure it would change the analysis, but it seems to me
But
there's enough of them, as you say, you might put it in the form.
well, there's only this one at this point, I think, and out of thousands of cases, I think that's a good indicator that it's working very smoothly, and these defendants are getting their chance to challenge the parole revocation cases. And I point out that Zoom actually works to the parolee's benefit oftentimes, because their witnesses have to come during business hours. These hearings are held during business hours, and their witnesses have day jobs, they have childcare responsibilities, other responsibilities that they probably wouldn't, or a lot of them would not be able to make an in-person hearing, where Zoom allows them to call these witnesses that wouldn't otherwise be able to attend the hearing in their defense. So it's not just for the state. Everybody benefits from the use of this technology. So that's why it falls into that, I think it's Scarpelli, it says, it falls into a creative solution that addresses the practical problems of these hearings. And The Supreme Court specifically left that door open. I think they were anticipating possibilities like this, where technology enables you to navigate these practical difficulties.
When you just said everybody benefits from using Zoom, are you including the criminal defendants in that?
Yes, or no, sorry, not criminal, but parolee. Ultimately, Zoom hearings safeguard the Supreme Court's interpretation of the Due Process Clause, because the Supreme Court has, for 50 years, continued its recognition and encouragement for states to seek these creative solutions. And Zoom is that creative solution. It's a technology that preserves the salutary aspects of confrontation while removing the logistical, safety, and financial hardships associated with having in-person hearings.
What about if, I mean, this is hypothetical because it's not in this case, but if you have some breakdown in the Zoom process where somebody's image is not available, right? Instead, there's a picture of a cat, for example, right?
Yeah.
What about that? I mean, are we gonna have to just if we agree with you that generally when Zoom is working all the time, it might satisfy, the needs of the moment, but if there's a cat picture, we're gonna have to address that on a case-by-case basis,
Or does the hearing officer have to proclaim good cause?
No, I mean, certainly in certain cases, if there's some issue with the technology, that can come up in a case-by-case basis. And yes, if you're denied your ability to view the witness, I would say that implicates the due process right to confront also, because all the cases do support that you need to be able to observe the witness's demeanor.
But along the same lines, you wouldn't deny, would you, that it's different when you're looking at a person's image on a screen versus when you're looking at them in person? So, I mean, where is that line? If you agree that we have to be able to look at the person, anyway.
In my experience, I don't think there's a real difference. I mean, yes, it's a little bit different, but in terms of what the goal of, I think the goal, according to Morrissey, is to have an informal hearing structured to assure that the finding of a parole violation will be based on verified facts and the exercise of discretion will be informed by accurate knowledge of the parolee's behavior. Zoom does that. You have that in this case. You're able to verify whether he reported to his parole officer. You're able to verify whether he had his GPS monitor cut off. Zoom did not interfere with that. And I see
Do you think, you're out of time, but I'll ask you one question, I'm gonna let you
Yes.
answer if you want, if you're brave enough. Do you think America's school children were educated as well over Zoom as they were?
No, I don't.
I have one question. How does Howard County get jurisdiction over this since it's a state parole case? Is it by virtue of the prison unit being in your county?
He was convicted in Howard County.
Okay.
Thank you very much.
Thank you.
We'll now have rebuttal.
Thank you, Your Honor. May it please the court. Yeah, not everybody is benefited by Zoom testimony. TDCJ, with its parole division, is benefited by by Zoom testimony because they can make their cases easier. But
To
TDCJ,
his point, isn't the prison population served better? I mean, if they have to pay witnesses or subpoena witnesses and have them show up for live hearings, how many of its prisoners can go on vacation from prison?
they shouldn't have to go on vacation from
But if
prison.
they're on parole, they're subject to being called back, subject to whatever the terms of the parole are.
Granted, Your Honor, but TDC has a whole division, the Transportation Division, which specializes in moving inmates around the state. Surely they can move them to where the hearing officer is or where the parole officer is, and without a whole lot of trouble. Now, in this case, to my simple mind, I apologize to anybody who disagrees, this case is very simple. That Morrissey versus Brewer says confrontation is guaranteed, subject to a good cause examination.
So counsel, on the record in this case, could you think of some examples of what good cause would have been or could have been?
Something like the nurse witness in Haggard, that she was in Minnesota and the trial was down here in Texas, and she first said she could come and attend, and then she said she wouldn't because her way wouldn't be paid or something or other, or her salary wouldn't be paid.
No, but in this case, given the state of the record, like what, can you cobble together something that might approach good cause in this case?
Yes, I would have thought that somebody being well out of the jurisdiction, good cause would permit Zoom testimony in that limited sort of circumstance. But here, there were no witnesses from a protected group like frightened children. There was nobody far away in Minnesota or wherever. Everybody could have attended. Most of the witnesses, or maybe all of the witnesses, were from Lamesa County, which is just one county over. They were 40 miles away. It's not a big deal. Back in the it seemed, to my knowledge, these hearings were all live until COVID hit, and then it wasn't within the Supreme Court's orders, because this is a constitutional issue to which the Supreme Court orders didn't apply, but there was possibly some justification for having Zoom hearings. But then after COVID hit and the Supreme Court orders were done away with, what justification is there? I did some of these hearings back in the 1990s. Back then, the parole board maintained the fiction that parole revocation proceedings are not an adversarial matter. The hearing officer in Amarillo, who was a friend of mine, used to poke at me and say, this is not adversarial. But if you put an attorney worth his salt in this, they are going to be adversarial. I heard the state say that there was no dispute over the GPS monitors. There was. I always dispute the reliability of those monitors on the straps that people get chained to their ankle. I did cross-examine witnesses. The fact that the failure to pay was not sustained was pretty easy, because the parole officer, if you raise a defense of inability to pay, the parole officer has to try to overcome that. That's a pretty high burden, so they're almost always not sustained. The failure to report often is not sustained because the parole officer shows up at the person's house, says, oh, they weren't there, but I left a note. Yeah, but as the hearing officers have said to me, and I've objected on this basis, did he get the note? Did somebody else who lives there get the note and throw it away? We don't know. So that allegation should not be sustained. Here it was sustained.
Counsel, let me ask you something.
Your Honor.
I heard you say earlier that the in-person allows effectively a better evaluation of the credibility of the witness. All right. Assume this hypothetical.
Yep.
All witnesses, defense counsel, and defense are in the courtroom, but the judge appears via Zoom. Does that eliminate entirely your confrontation clause issue, but does it leave your due process issue remaining? Or in that situation, would you have no problem with it?
Is the jury in the room, Your Honor? Or is the fact finder?
Parole, right? In a parole, excuse me, in a parole revocation.
The hearing officer is in another room.
Yes, the hearing officer is via Zoom. Everyone else appears personal.
Then, yes, that is not confrontation cross-examination, because the fact finder does not have the true ability to distinguish what the witness is doing with his hands as he's saying.
So from your perspective, in that scenario, it would still be a confrontation clause issue?
Yes, Your Honor. Most definitely.
And would you agree with me that a really good trial lawyer can decimate a person in person when it's an in-person situation, and if it's the same thing happening on a TV screen, he may actually lose?
Exactly, Your Honor. I mean, we see Law and Order, and the defense attorney gets right up in the witness's face and points at him. And I don't know if any trial court allows that. I've only done one trial. And
Smoking cigars either.
Exactly. I see I have a few minutes. If the court has any questions, I'll be happy to answer them. No? Okay, thank you all very much.
Thank you. This case will now be under submission, as will our earlier case. We thank counsel for their appearance here today and for their very fine arguments. The court will now stand in recess until it reconvenes.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.
You can, certainly.
actually have to. I actually have to.